Back now to the breaking news that the Supreme Court has granted the Trump administration's emergency appeal to temporarily block a court order to fully fund SNAP food aid payments amid the government shutdown. A federal appeals court had left an order in place that required the president's administration to provide those full SNAP food benefits for the month of November while the government remains shut down. For more, we are joined live by legal analyst Neama Rahmani, former federal prosecutor who is now head of West Coast trial lawyers in L.A. So, Neama, what does this mean for the millions of Americans and the many people here in California who depend on these benefits?
Margaret, it means they're not going to get them anytime soon unless the government shutdown ends. There's a comprehensive spending bill, a continuing resolution, an independent bill related to SNAP benefits, or some states like California may choose to fund the benefits themselves. Let's not forget, the SNAP program is a federally funded program, but it's administered by the states. So here in California, through the CalFresh program, for instance. So the state wants to draw from its own budget, hoping that it will be reimbursed by the feds when the government reopens. That may be a possibility, but it's going to be very state-specific, and at least as far as the legal case is concerned, this was a huge step back for SNAP benefits.
Yeah, I mean, there was certainly confusion a little bit earlier today because we had gotten word from the USDA that they were going to fully fund the SNAP benefits, and then we get this where the administration goes now and appeals to the Supreme Court. What do you make of all that?
So there's two pools of money, and that's why there's some confusion. So under the Food and Nutrition Act, the U.S. Department of Agriculture shall fund the SNAP program. The problem is there's not enough money there. So if you remember last week, there was some litigation over $5 billion in contingency funds. The department argued that's for a natural disaster, a real emergency, not partisan gridlock in Washington. But that $5 billion is not enough to fund the SNAP program because the program costs $8.5 to $9 billion a month. So what we're talking about today and yesterday is a separate pool of money. It's WIC money. So that's women, infants, and children. Now there's $23 billion in that pool, and that is authorized by a much older statute, the Agriculture Adjustment Act from the New Deal in the 1930s. So the judge in Rhode Island yesterday said that the USDA must pool from that pool of money. So the WIC program costs about $3 billion a month, so there'd be plenty of money to fund the SNAP program fully, at least through the end of the year. The government said, no, that's a separate pool. You can't rob Peter to pay Paul. And they appealed to the First Circuit Court of Appeals. That's the intermediate appellate court, asking for a stay or a pause on that ruling. That Court of Appeals said no, but the Supreme Court said yes. So now that pool of money, that $23 billion, is not available for food stamp recipients.
And this order by the Supreme Court is an emergency order temporarily blocking the full SNAP food aid payments. How temporary is that? I mean, what's the time frame here?
Well, it puts that order on hold until it goes through the full appeals process. We know that can take months, maybe even over a year before it makes its way through the regular briefing, schedule, and oral argument. Usually a rule of thumb for an appeal is anywhere from 12 to 18 months in the federal system. So obviously, people can't wait that long. So even though it's a temporary block, for all intents and purposes, Margaret, it's a huge loss for these states, these cities, and nonprofits that sued the federal government to mandate and try to mandate that they fund the SNAP program.
All right. Legal analyst Neama Rahmani, thank you so much for your time. As always, appreciate it.
Of course, Margaret. Great talking to you as always. Have a good weekend.
You too.